What's up, everybody? Steven Lefkoff here, Lefkoff Law. I get this question a lot. I thought I'd answer it today with an example. The question is, what do you do for car dealers? Right? I say all the time that I represent car dealers, finance companies, repairers, auctions, tow companies, businesses in the motor vehicle space. And it's not as easy as defining what do you do. I do personal injury, or I do divorce, or I do bankruptcy, right? That's an easy definition. It's a harder definition. What do you do? I represent dealers. Well, what do you do for dealers? Runs the gamut. So I thought I'd talk about something that happened yesterday that I thought was really interesting for me. Hopefully you find it interesting. I've got a case right now for a dealer here in Georgia. It's in the Superior Court of one of our local counties here outside of Atlanta. And in that case, about 2.5 years ago, the dealer sold a car to a customer who's out of state. The customer found the car online. The car had photographs. The listing had images and photographs of pictures of the car, and it had a description. In the description, it said that the car had a certain package, and in that package would contain certain features, right? The description on the listing also said, basically, don't trust the listing, inquire to verify that the features are as they say they are in the listing. The customer from out of state calls the dealership about this car. It's a $75,000 Mercedes. And the customer says, texted the dealership, and in text messages confirmed with the dealership, the customer said, does it have this feature? And the dealership salesperson responded, it has this package, right? So the customer specifically asked, does it have rear AC controls? And the salesperson responded, it has the, quote, executive rear seat package. The customer thought, okay, that must have satisfied the customer because the customer didn't ask any further questions and bought the car. The customer purchased the car without coming to Atlanta to check it out, without test driving, without getting an inspector to come look at it, without contacting Mercedes to verify if any of the features were on it. She instead bought a used car, as is, sight unseen, from out of state, right? She lives in a different state. When the car got to her, she immediately noticed that it did not actually have the rear AC controls. So what did she do? She sent a text message to that same salesperson saying, hey, the rear AC control is not here. It's not on this car. She took a picture of the rear console of the car where the AC control would be, and it just was blank, right? It was a little pocket to store items and tchotchkes and things. So she took a picture. She said, look, it's not here, right? That same picture, however, or a picture from that same angle, is on the listing of the vehicle, showing, in fact, it's not there. But she did text the salesperson before buying and asked if it had the rear AC control, to which, again, the salesperson responded, it has the executive rear seat package. The parties are unable to come to a settlement on the deal, and so the consumer files a lawsuit against the dealership. I defend the dealership in this case. Interestingly enough, yesterday we had a hearing on a motion for summary judgment. What's a summary judgment? A motion for summary judgment is when one party files a brief with the court, or a motion with the court, and generally attaches a brief with argument and authority, saying essentially, Judge, we don't need to go to trial on this case. We win as a matter of law. The judge can decide right then and there that the party filing the motion wins and there's no need to go to trial. Well, the plaintiff filed a motion for summary judgment on the Fair Business Practices Act claim that she had. Georgia's Fair Business Practices Act says essentially you can't perform an unfair business practice to a consumer as a dealer. Now, there are a whole lot of nuances. I could go on for hours on the different levels and what you have to prove and what you have to show, et cetera, et cetera, et cetera. But two of the things that I found interesting in defending this case were one, the Fair Business Practices Act requires notice. OCGA 10-1-399B says specifically that at least 30 days before filing suit, the claimant has to send a written demand to the respondent. Okay, that would be, in this case, the claimant is the plaintiff, is the consumer. The respondent is the dealership. The claimant would have to send a written demand to the respondent, identifying, number one, that she's the claimant, number two, the injury suffered, and number three, that there were damages. Or number two, I guess, is the alleged unfair practice, and three, that there were actual damages and what they were. Legal issue here that I found very interesting was, number one, whether the text messages were sufficient notice. Now, there's no law in Georgia. There's no case. The Fair Business Practices Act is like 30 plus years, 40, almost 40 years old now. It doesn't address whether text messages satisfy the notice requirements that it be a written demand. So we don't know the answer to that question. And number two, I found interesting, was the Fair Business Practices Act requires what's called reasonable reliance. It's the same level of reliance in a fraud case. What does that mean? That means that the consumer has to have reasonably relied on the statements of the respondent, right? In this case, the dealership. So the question in this particular case is, was it reasonable for the consumer to rely on the statements of the dealership that it had the executive rear seat package to buy the car, right? And to rely solely on that. Now, of course, my argument, right, my client's position is, no, it's not reasonable. She bought a car sight unseen. She didn't go see it. She didn't take a test drive. She didn't get it inspected. She didn't have anybody else come see it. She doesn't live that far away. She lives in a neighboring state to Georgia. And she paid $75,000 for a car as is. Forgetting the issue of the features. If the car had a problem with its engine, she wouldn't have any recourse. If the car had scratches all over it, she wouldn't have any recourse at all because she bought it as is. Is it reasonable for somebody to do that? Of course, my argument's no. Now, on the flip side, the plaintiff says, well, wait a second. She did ask, and it was confirmed by the dealership that it had the feature. What more does she need to do, right? What's a reasonable consumer supposed to do? She looked at the listing. The listing had said it had the feature. She texted the salesperson, and the salesperson said it had that feature. So yesterday, we had a summary judgment argument and hearing before the Superior Court. And those arguments were brought out by both attorneys. The judge did something called the judge took the arguments, what's called under advisement. What that means is the judge is going to kind of think about it all and make a decision later. We're going to get the decision in the mail. As I'm recording this video, I have absolutely no idea in what way the judge is going to rule. He could do one of three things. He could rule in favor of the plaintiff, right? If he does that, then summary judgment's granted in favor of the plaintiff. Plaintiff wins. We then have a hearing on damages, right? How much is the plaintiff entitled to in a judgment against my client? No trial. Plaintiff wins. He could rule in favor of the defendant. Now, there are two different ways to rule in favor of the defendant. I guess a 2A and a 2B. 2A would be ruling in favor of the defendant by denying the plaintiff's motion and saying, the plaintiff, you didn't carry your burden here. You didn't show me as high as you need to show on a summary judgment that you win. So I'm going to let this go to trial. Number 2B, letter whatever, 2B, would be if he rules in favor of the defendant. Now, I filed something called a cross motion for summary judgment, which says essentially not only is the plaintiff wrong here, right, but the evidence is so clearly in favor of the defendant that the defendant should win right now with no trial. That it's so clear that, number one, the notice wasn't proper, and number two, that the plaintiff didn't act with reasonable reliance, that her reliance wasn't reasonable. And so the judge could rule 2B in favor of the defendant in such a way that the judge says, I'm granting the defendant's cross motion, and the case is over. Defendant wins. Or C, right? C is, I'm denying it all, and we're going to go to trial. I guess that's similar to 2A. We don't know how the judge is going to react, how the judge is going to rule. We don't know when the judge is going to rule. I've been in cases like this where I get a ruling in a week and a half, 10 days, something like that. I've been in other cases where it takes months. So I don't know. I'm excited to hear. I'm anxious. I want to know what happens. This is a big case. There's a lot of money riding on the line for this local dealership. I know my client's excited to hear. I'm sure the plaintiff and the plaintiff's attorney is excited to hear. But I thought about this case a little bit today. It's kind of still on my mind. And I thought that question of what do you do, right? What do you do for your clients? This would be a perfect example of something I do. I'll come back with more videos on other things that I do as they come up. But right now, I wanted to talk about that piece of litigation in the Superior Court. I'm here at the beautiful City Springs in Sandy Springs, Georgia, downtown Sandy Springs. My name is Steven Lefkoff, Lefkoff Law. If you are a dealer, finance company, or you need any help, please don't hesitate to give me a call, 404-482-2228. Have a great day.